Welcome back to the deep dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure.
Yep, still digging in.
Today it's chapter 400, covering the representative of applicant or owner. Specifically, we're tackling a pretty serious situation.
We are. Section 407. Suspended or excluded patent practitioner. Basically, what happens when your patent attorney or agent gets kicked out of practice before the USPTO.
Oof. Yeah, that sounds high stakes.
It really is. And this section isn't just, some administrative detail. It's fundamental to the integrity of the patent process. It's about making sure applicants are only represented by people in, well, good standing with the Office of Enrollment and Discipline, or OED.
Got it. Protect the applicant, protect the system. So our mission today: unpack what happens immediately to the power of attorney, figure out how the USPTO communicates when representation vanishes, and crucially, understand how the filing date affects who can actually sign stuff.
Exactly. Let's dive into that first consequence. It's immediate and, frankly, harsh. When a practitioner is suspended, or worse, disbarred by the USPTO, any power of attorney they hold becomes ineffective. Instantly.
Wow, instantly. No grace period.
None. Zero. Their authority to act for that client in any patent matter just evaporates. Poof.
Okay, so if the POA is gone and the USPTO won't talk to the suspended person, what happens to the application? How does the applicant even know what's going on?
Right, that's the critical next step. The USPTO is very strict. They will not communicate with that suspended or excluded practitioner, period.
So where does the mail go?
It gets rerouted.
Yeah.
All the office actions, all correspondence, it has to be mailed either directly to the applicant of record at their correspondence address.
Okay.
Or if there happens to be another representative still listed who is in good standing, it might go to them too. But the applicant will get notified.
That feels like a huge potential problem for the applicant, though. I mean, they hired a lawyer. They might not be checking their own mailbox expecting official USPTO actions.
That's precisely the risk, and why this rule is so important. The burden shifts immediately back to the client. You have to know this might happen, and you have to be prepared. Missing that first redirected office action, that's on you. The clock starts ticking.
So the rule basically forces the applicant to wake up, take charge, and find new representation fast.
You got it. Vigilance is key. Now, let's talk about who can actually sign the papers needed to keep that application moving forward, because the original person is out.
Right, and you mentioned the filing date is the big dividing line here.
Yes, absolutely. The rules depend heavily on whether the application was filed before September 16th, 2012, or on or after that date. That's the cutoff for the American Invents Act, the AIA.
Okay, let's start with the old days. Pre-September 16th, 2012, if there's no valid POA because the attorney got suspended, who signs?
The pre-AIA rules were quite specific and could be complex. The general idea was getting sign-off from everyone with a legal interest.
Like who?
Well, for instance, all the named applicants had to sign any papers submitted, unless, one applicant had a specific documented power of attorney to sign for the others, but that's an internal agreement.
All of them? What if there are 5 inventors?
Yep. All 5 might need to sign. Or scenario 2. If an assignee, say a company, owned an undivided part interest, then you needed signatures from all the original applicants who still held some interest, plus the assignee.
Getting complicated.
It could be. Third scenario. If an assignee owned the entire interest, then just that single assignee could sign. Much simpler.
Okay.
And there was a fourth path, kind of a safety valve. Papers could be signed by a different registered patent attorney or agent, one who wasn't formally of record yet, but was acting in what's called a representative capacity under Rule 37 CFR 1.34.
1.34. That sounds like a key rule. What does acting in a representative capacity actually mean here? Like a temporary stand-in?
Sort of. It means they're a registered practitioner, fully qualified and in good standing, but they haven't filed the official power of attorney document to be formally recognized for this specific case yet. It allows them to take urgent actions, like filing a response, to prevent abandonment while the formal POA paperwork is sorted out. It's an emergency measure.
Okay, that makes sense. So the pre-AIA system sounds like it could involve chasing a lot of signatures in a crisis. Did the AIA simplify this for applications filed on or after September 16th, 2012?
It did streamline things in some ways, but it introduced a really critical distinction, especially for companies.
How so?
Under the AIA rules, filings can generally be signed by a practitioner of record, or under that 1.34 rule we just discussed, or simply by the applicant themselves.
Oh, so the applicant signing directly is easier under AIA.
For an individual applicant, yes.
Mm-hmm.
But here's the massive caveat. If the applicant is a juristic entity, Think corporation, university, nonprofit, any legal entity that isn't a person.
Mm-hmm.
Then only a registered patent practitioner can sign the filings.
Whoa, wait. So if Google's patent attorney gets suspended, the CEO of Google cannot sign the response to an office action.
Correct. Not the CEO, not the head of R&D, not their in-house general counsel, unless that person is also a registered patent practitioner before the USPTO. That juristic entity must have a registered practitioner sign.
That's a huge difference. Why the change?
It really emphasizes the need for qualified representation when dealing with corporate or organizational applicants. The office wants to ensure someone versed in patent law and procedure is handling things, especially post-AIA. It's a gatekeeping function, ensuring professional handling.
Okay, that's a critical distinction for businesses to understand. So we know the POA is void, communication gets rerouted, and signing depends on the filing date and applicant type. How does the Patent Office actually manage these cases internally? Do examiners have specific instructions?
They do. The MPP provides practical tools to make this smoother and ensure proper notice. Section 407 gives examiners 2 specific form paragraphs, basically pre-written templates to use in official correspondence when this happens.
2 forms. What's the difference?
It depends on the representation situation. Form paragraph 4.07 is used when the only practitioner on the case gets suspended or excluded. It goes straight to the applicant, telling them their rep is out and future mail is coming directly to them.
Okay, that's the clean break scenario. What's the other one?
Form paragraph 4.08. That's for when there were multiple practitioners listed, maybe a whole law firm, and only one of them gets suspended or excluded, but others remain in good standing.
Ah, so representation technically continues. How does communication work then? Is it safer for the applicant?
It provides an extra layer of communication. In that 4.08 scenario, the office will continue sending correspondence to the remaining authorized practitioner on file.
Makes sense.
But, and this is important for protecting the applicant, the rules also require the correspondence to be sent to the applicant's address of record.
Oh, so double notification to the remaining lawyer and the client.
Exactly. It's a redundancy check. It ensures the client gets direct notice, just in case something falls through the cracks with the remaining firm or lawyer. It prevents the client from being left in the dark if there's internal confusion at their law firm.
That seems like a smart safeguard. So the applicant gets this notice, maybe form paragraph 4.07 or 4.08 lands in their mailbox. What's their immediate job?
Act fast. The strong recommendation, really the necessity, is to file a new power of attorney as soon as possible.
Designating someone new, obviously.
Yes, designating a registered patent attorney or agent who is confirmed to be currently in good standing. You can't just pick anyone.
And how do you confirm that status, especially if you're scrambling to find someone new?
The USPTO helps with that. They maintain an online directory accessible through the Office of Enrollment and Discipline, the OED. You can look up practitioners there.
So you can check if someone is active and in good standing, or even find potential new representatives.
Precisely. You could verify the status of someone you're considering, or search for qualified practitioners. Using that OED resource is really essential to getting proper representation back in place quickly and keeping the application process moving smoothly.
Okay, so let's recap this Section 407 deep dive. The core takeaway seems to be that if a patent practitioner gets suspended or excluded, their power of attorney becomes instantly void.
Instantly, no question.
The USPTO stops talking to them and redirects all mail to the applicant directly, or maybe to another valid representative if one exists, but always includes the applicant.
Right. The applicant is always put on notice.
And then who signs future documents depends critically on that September 16th, 2012 AIA filing date, with pre-AIA often needing multiple signatures, and post-AIA allowing the applicant, unless it's a company, which must use a practitioner.
That juristic entity rule is key post-AIA. And the office uses specific forms, 4.07 and 4.08, to manage the communication clearly. The onus is then squarely on the applicant to file a new POA with a verified, good-standing practitioner using the OED directory to help.
It really underscores how vital verifying your representative's status is, not just initially, but potentially ongoing.
It absolutely does. Which leads to a thought I want to leave you, the listener. We've seen how heavily the system relies on the current standing of the practitioner for its integrity. So here's the question. How does the fact that practitioner status is publicly available right there on the OED website fundamentally change or influence how you, as an applicant, might approach choosing, vetting, and maybe monitoring your patent representation? Something to think about.
Definitely something to consider. Before we wrap up, we want to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
And as always, our important disclaimer.
Right. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM. It might contain errors or omissions.
It's for general educational and informational purposes only. It is definitely not legal advice, nor is it a substitute for formal instruction.
For authoritative guidance, please consult the official MPEP itself, talk to a qualified instructor, or best yet, engage a registered patent practitioner.
Absolutely.
Thanks for joining us on the deep dive. We'll catch you next time.